Facebook and Twitter users have been warned they could be inadvertently breaking the law by commenting on court cases online.
The government's chief legal advisor is to issue advisory notes to warn social media users what information does and doesn't abide by contempt laws.
Well, with us now is media lawyer Rupinder Bains and blogger and tweeter Susie Boniface, also known as Fleet Street Fox. Hello to you both. Rupinder, the Attorney-General has talked about issuing advisories that would normally have just gone to the media, to the public. Is that going to make any difference, do you think?
Well, considering you have to either follow him or log on to his website, I don't think it's going to make a hell of a lot of difference straight away, but it will do in the due course of events when people are arrested, charged and prosecuted for offences of contempt of law, contempt of court. What the problem is that he hasn't covered is what happens when people tweet from overseas, or if people have fake accounts set up. These things haven't been covered and they won't be caught by these new advisory notes.
Susie, the problem now is that anyone can broadcast information via social media. We as journalists are trained in what we can and can't say. That doesn't count for the public, does it?
Well, no, it's asking an awful lot of the general members of the public to have the same grasp of the law that journalists need to have on a daily basis, from sexual offences to lifelong anonymity orders and contempt of court and defamation. But at the same time, those people who are on social media are fully aware that those are risks now. We all know what has happened, whether it's Peaches Geldof, whether it's today's announcement, whether it's what happened with Sally Burkow and Lord McAlpine, or even in the Ched Evans rape case last year when some people were prosecuted for naming a rape victim. We know what happened, and it's merely a case of using common sense more than anything else. If there was in this case, Peaches Geldof tweeted the names of the parents, mothers who were involved in the Ian Watkins rape case, and she did that because she saw the newspapers weren't doing it. Now, if common sense had prevailed there, you'd think, well, there's probably a good reason why all newspapers, reputable and otherwise, have not used these names. And it's just a case of having that common sense.
I mean, so the first bit of advice would be to follow the Attorney-General, would it?
Well, absolutely, yes.
Yeah, and how much of a problem is this really causing now, social media, in the wider legal system? Of course, we hear about high-profile cases, but are there lots of ones we are not hearing about?
Well, yeah, there are. I mean, social media now, the news network out there is 24 hours. It's there. It's available to everybody. It's the traditional concept of media being broadcast in newspapers is no longer the norm, if you like. Everybody is online, whether it be social media, whether it be by emails, and everyone's got an opinion on everything. So, it is heavily influencing everyone. And if we think that the juries...
I mean, are we getting libel cases and things coming from people tweeting to probably a
we see
few
this
hundred followers or something?
day in, day out. And celebrities in particular, if they tweet something to their hundreds of thousands of followers, then, they are very influential. And we see on a daily basis blogs or, postings on websites which are causing concern.
Do you think this is something then that needs to be taught in schools, basic law, so that people are aware of the power of social media and what they can and can't say?
I don't know about teaching it at schools. I'm not quite sure of the efficacy of the Attorney-General going onto Twitter. I don't think he realises quite what's going to happen. As soon as he puts out an advisory note to people, he's going to be deluged by people calling him names, offering insults, being funny, satirical. I mean, I can just imagine what would have happened had he gone onto social media and tried to say, please don't mention the super injunction anybody, because everyone just replied saying Ryan Giggs in big letters. It's a very irreverent forum in trying to get people to do one particular thing. It's quite difficult.
You built up a successful Twitter following and a blog, and you're also a tabloid journalist. Do you apply different rules to those different things?
No. It's the same rules all the way through. And in fact, what I've come to realise as well, having done that, is actually the rules are much stricter and more difficult online because you're influencing potentially more people.
But you're more personal, aren't you? When you write about yourself or having a drink or whatever, then you wouldn't put that in the paper.
Yeah, I think the main difference is that journalists are taught that there's a difference between comment and news reporting, and that's where the difference appears to not quite be working online. People think that their opinion is the same thing as the news, and if their opinion is these people should be named, therefore I can do it, and it's not. You have to follow a slightly stricter guidelines.
What are the implications, Rupinder, if somebody does publish something that is in contempt of court on Twitter or Facebook?
It's a strict liability offence now, so it's always been a strict liability offence, but you can be fined, there can be prison sentences. It's something for which you will be prosecuted.
But there has been quite a lot of pushback on Twitter today. People saying, you know, basically you can't catch all of us. It is going to change, isn't it? I mean, the comment is going to become freer because it can't be policed.
Yes, and I think it's going to be more taken account of when the first person is taken to account over this. But again, if someone tweets from abroad or if somebody has a fake account, there's no guidelines for that, so people will escape. They'll find ways around it.
Yeah, I think this is what we're probably going to do. Is this going to have to lead as well to, at some point, having to rewrite some of what these laws are about. The Contempt of Court Act 1981 isn't really fit for purpose these days in modern era. As we've seen in the slaves case in South London, people have been talking about this as though it were a fact, and it is still an unproven allegation at the moment. And the Attorney General hasn't told anybody to stop reporting the word slave or saying things differently. You know, it's not working.
Well, we actually got a press release from the government relating to a current case, a government initiative relating to it, and our lawyers felt that we couldn't repeat that. So perhaps it works both ways.
Yeah.
Thank you both very much.
Thank you.